Donald Trump has appealed his claim of absolute immunity to the Supreme Court. The former president is pushing to extend the delay in his election interference trial, arguing he is immune from prosecution. A federal appeals court rejected that claim last week, saying the case would return to trial. Let's bring in Jessica Levinson. She's a CBS News legal contributor and professor at Loyola Law School. Jessica, it's good to be with you again. What happens now?
What happens now is really the Supreme Court is going to decide whether or not to take this case. And let's remember the appeal that comes to them, the lower court decision here. It's a 57-page opinion from 3 judges on the D.C. Circuit who have different ideological backgrounds, and they issued a per curiam opinion, meaning they spoke with one voice, no concurrences, no dissents. They really kneecapped each of former President Trump's arguments here, all of which is to say the Supreme Court is deciding whether or not to review a quite complete and thorough D.C. Circuit decision on this issue of presidential immunity. So I think there's a chance that they just don't take the case at all, even though it is a matter of first impression, even though it is the type of thing you would typically see the Supreme Court review.
And what do you make? I know it's 110 pages, but what do you make of the filing?
So what I make of the filing is that the former president is making the same argument that he made before the D.C. Circuit, which is that you simply can't subject a president, in this case a former president, to criminal prosecution for official acts, that it harms not only the separation of powers, but it also would upend the impeachment clause. Their argument here is that you need to be impeached and convicted in order to be tried in a criminal court. The D.C. Circuit rejected both of those contentions, but they're bringing them back, as is quite typical for the losing side in an appellate argument. They're bringing them back now to the Supreme Court.
And now I'm going to jump us down to Florida, because the former president spent 4 hours in a federal court in Florida on Monday over the classified documents case. Can you give us the nickel tour of what's happening there?
Yes, it's whether or not the defense, in this case, of course, the former president, gets access to certain classified documents. So we understand that the day was basically divided in 2 different ways. That the first part was a hearing with both the special prosecutor and the defense about whether or not the defense team would get more of these classified documents. Of course, this is not a typical argument that people have, because typically speaking, in a criminal case, you don't have classified documents at issue. And then I believe that the second part of the day, the afternoon, was the judge just meeting with the special prosecutor. This continues, let's say, conversations between the special prosecutor and the judge, where the special prosecutor has said, let's keep this information private, really pushing the judge at times to reconsider her rulings.
It'll be fascinating, some of the most sensitive national security secrets there are. Jessica Levinson, thank you so much for being with us.